And now we'll hear from Ann Teigen from NCSL.
Yes. Can you hear me?
We can. You're on
Okay,
high.
great. Okay. Well, I'm sorry that I don't have a PowerPoint, but I just want to introduce myself again. I'm Ann Teigen, and I'm a program principal with the National Conference of State Legislatures. And NCSL is a nonprofit bipartisan organization, and among our goals is to provide legislatures with information and research about policy issues, both state and federal. For the last 10 years, I've been tracking traffic safety issues for NCSL, including impaired driving and drug driving. And I'm just going to give you an update on what's going on nationally related to impaired driving legislation. I did want to mention that some of my work is funded through a cooperative agreement with NHTSA. All of the traffic safety issues that I cover are funded through that. So I definitely don't want to repeat what Frank had talked about, but I wanted to let you know that in 2016, lawmakers in 42 states introduced approximately 380 bills related to impaired driving, which what we monitor is impaired by alcohol or drugs. And ultimately, 79 of those measures were enacted or adopted. This year, so far in 2017, there are about 300 bills introduced. So I look at legislative trends, and in the last few years or so, lawmakers are considering legislation related to 4 or 5 trends, and I'm going to talk about each of those for a moment, just to give you the legislative landscape. The first one is BACs and high BACs. Most notably, just about a week ago, the Utah House and Senate passed House Bill 155 that would, if signed by the governor, make Utah the first state in the nation to have a blood alcohol content threshold for DUI be a .05 instead of a .08. There has been news that the governor is definitely going to sign it. There has also been news that he might sign it, and then so we'll just have to wait and see. But it's pretty significant that it passed both chambers. Hawaii and Washington proposed similar legislation this year in 2017, and in the past decade, a handful of states, New York, Vermont, Oregon, they've all considered but have not passed lowering the threshold. States have also enacted high BAC laws with enhanced sanctions for offenders with high BACs. And of course, the sanctions vary from state to state, but usually include a longer license suspension, longer terms of imprisonment, additional fines, installation of ignition interlock, and vehicle sanctions or mandatory treatment. The BAC levels at which these sanctions apply vary as well, ranging from .15 to .20, but states have been introducing legislation in the past couple of years to lower the high BAC threshold level. For example, in 2015, Minnesota lowered the BAC level that constitutes a gross misdemeanor DUI from .2 to .16. So that change exposes offenders to a maximum 1-year jail term, up from 90 days under the misdemeanor standard, and it would triple the fine. So another, obviously, legislative trend that Frank did mention is the ignition interlock requirements. All 50 states have passed some sort of legislation that allows or requires the use of ignition interlocks. And as mentioned, about half the states require ignition interlock devices for all convicted drunken drivers, including first-time offenders. That is up from just 7 states about a decade ago. So that's a pretty significant increase. Most recently, Maryland and Pennsylvania enacted their requirements in 2016. California currently has a 4-county pilot program that includes Los Angeles that requires all convicted drunken drivers to install ignition interlock devices. And in addition to the pilot program, California amended their law in 2016 to require or allow use of ignition interlocks in several other circumstances. I would note when I was researching this presentation that there has been a bill introduced in Arkansas this year that would change the language a little bit and change the mandatory requirement and essentially allow a person to choose not to drive during a suspension and not install an interlock. So I just wanted to point that out because I found that bill to be a little bit of an outlier, but interesting. States that don't have a mandatory ignition interlock for all offenders are still expanding their laws. For example, in Kentucky, in 2015, Kentucky passed a law that requires ignition interlock installation for all repeat offenders and for first-time convicted drunk driving offenders with a BAC of 0.15 or greater. The law also requires an interlock for those who refuse to take breath tests. Frank spoke a little bit about compliance-based removal, and I'm definitely seeing that as a trend. I'm also seeing states are enacting legislation that require some or all offenders to install interlock devices that are equipped with a camera to ensure that the driver is the person taking the test to start the vehicle. Virginia most recently adopted something in 2016. It wasn't adopted legislatively, but they've recently adopted something. And then also in Colorado, the requirement isn't in statute, but all DMV contracts with ignition interlock vendors require cameras. The other thing that I've seen a little bit in the past couple of years is Washington, Minnesota, Missouri, Vermont, and most recently South Dakota have provisions in their laws requiring at least some offenders to have interlocks with global positioning capabilities, and that has been a little bit controversial. And for example, it's in Minnesota, it really has started a lot of dialogue and back and forth about some privacy issues and things like that. So besides ignition interlock legislation, there are some other legislative trends that I'm seeing, and that has to do with blood alcohol testing and test refusals. In 2016, the U.S. Supreme Court held in Birchfield versus North Dakota that states may criminalize an arrestee's refusal to take a warrantless breath test, but if states criminalize the refusal to take a blood test, police must obtain a warrant. So 13 states currently criminalize the refusal to take a warrantless BAC test, and I've already seen some bills introduced in 2017, including from Arkansas, Florida, North Dakota, and Rhode Island, that would make changes to laws in an apparent response to the Birchfield decision. I'm also seeing a lot of bills related to enhanced criminal penalties for repeat offenders. In the last 2 years, around 8 states, including Colorado, Maryland, Montana, Oklahoma, South Dakota, Washington, West Virginia, and Wisconsin, have enacted legislation to enhance criminal penalties for DUI convictions for repeat offenders. Most notably, Colorado passed a felony DUI measure in 2015, and that was a pretty significant deal in Colorado. So the last legislative trend related to impaired driving that I'm going to talk about is the interest in using treatment programs and sobriety monitoring programs like the 24/7 sobriety monitoring program to prevent DUI recidivism. In 2007, South Dakota became the first state to pass a statewide program of this kind, and the pretrial program emphasizes offender sobriety and requires repeat and high BAC DUI offenders to submit to a breath or urine test twice a day at a local sheriff's office or another designated site. Breathalyzers, transdermal alcohol monitoring devices, and drug monitoring patches are also used to monitor the offender's sobriety. And if the offender fails or does not appear for a test, the offender's bond, parole, or probation may be immediately revoked, and in most cases, an infraction will result in some sort of immediate incarceration. Other states have started looking at this model, and Alaska, Idaho, Montana, North Dakota, Washington, and Wyoming have enacted some sort of enabling legislation or statewide legislation, Wisconsin most recently in 2016. And then the Utah legislature has also passed a 24/7 law here in 2017, but the bill is still awaiting the governor's signature, so it's not quite law yet. And these programs, they have not been without controversy, and they have been challenged in court, but for the most part, the courts have ruled that these programs are constitutional. So that is a very, very quick and dirty summary of some of my findings. I also wanted to respond a little bit to Frank's presentation. He mentioned kind of the difficulty with the bureaucracy and the hoops and things like that. And one thing that has changed, I'd say, in the past 5 years or so, is that many states have amended provisions in their laws to allow ignition interlock offenders to install the device almost immediately without a hard suspension, and some of that is related to changes in federal law that occurred a few years ago in MAP 21. But many, I'd say, about 10 states have changed their law to make it easier to get the ignition interlock installed faster. So I wanted to mention that too. And I would encourage you guys to visit ncsl.org. We do maintain a traffic safety legislation database that has tracked impaired driving bills for the past 10 years or so, and it can be a useful resource. So I will give it back to you and be ready for questions.
Terrific.